Blessings in Jesus' name. So, I'm an Irishman, and I've grown up in Ireland, been here for many, many years. And I'm not educated to a very high level, but what I do know is that our system here is very corrupt. That there's a systemic corruption as a result of witchcraft and the propagation of it in the state. What I mean by that is the state are basically representatives of Freemasonry, and Freemasonry are representatives of the devil. Now, of course, that's not the natural power structure as it was intended. So then, therefore, it's been occupied. Now, once the occupancy started to take place, those who were in responsible places, offices within the government, started to corrupt it. They didn't only corrupt it in terms of not carry out what they should have been carrying out, but they corrupted the system by making changes to it that they weren't entitled to. So where they started was by making amendments to the Constitution. And each amendment was made in a calculated way so that they could further corrupt it as a result of the amendment made. So every amendment was like an incremental departure from the Constitution at its core values. And those moral values are taken from the Bible, such that in the Irish Constitution itself, it says in the preamble, "In the name of the most holy Trinity, from and to whom is our final end, all actions both of men and states must be referred. We, the people of Era, humbly acknowledging all our obligations to our divine Lord Jesus Christ, who sustained our fathers through centuries of trials." So what's been said there? In the name of the most holy Trinity, that's the God of the Bible. All actions both of men and states must be referred to him, to the God of the Bible. Well, how do we know how to refer them? But by the Word of God. Because we don't have God on speed dial. We can't invite him into the Dáil for a discussion. So we refer to his Bible. We refer to the Word of God. And our forefathers did also when they were writing the Constitution. They knew what was good morality, and not only did they know what good morality was, they knew what systems worked and what systems didn't. They knew why those systems that didn't work, and they knew why the systems that did work did. And so that's why they enshrined those systems that do work into the Irish Constitution. So when that Constitution is abided by, when people do it properly, when they implement it rightly through the organs of state and government, in other words, they will ensure good and well-functioning structures within society that govern interactions between the citizens, that govern interactions between the state, and that enable the people, whether they be a citizen or somebody hired by the citizen like a judge or a guard or the state itself, hired by the citizen and paid for by the citizen, it will be accountable to the individual citizen, and it will be governed and structured in a way that the power structure doesn't become corrupted. That also goes for the democratic processes involved in electing people, the democratic processes involved in deciding upon statutes or alterations to the legislature. But alterations to the legislature should never be core values. Because if something that you've done, that you've called an amendment, in some way undermines the Constitution or the section of the Constitution that it comes from. In other words, if you have a branch coming out of a tree and that branch contradicts the tree, how will that branch grow from that tree? It doesn't. It becomes something separate. It falls off that tree. So what we've seen actually is not the Irish Constitution changing, but rather a departure from it. And it hasn't changed, because the core values of the Constitution are the same. So because the core values of the Constitution are the same and they don't change, and they can't change, without Ireland coming to an end, because the basic and fundamental constitution of a state is its fundamental and core identity. When people start to profess that they can make alterations that fundamentally change the system and how it operates, they're actually lying to you. But they make it appear like it's law by simply writing it into legislation. Now, when something's written into legislation, there's a process involved. Only the president of the country can sign something into legislation. I repeat, only the president of the country can write or sign something into legislation. In other words, he signs off on it. Now, I happen to know the current president is a Freemason. So, I mean, it's written into the Irish Constitution that you shall not be a member of a secret society and a member of An Garda Síochána, and that would extend to other offices within the state, not least of all the president of the country, who is given the duty or duty bound to sign things into legislation. What's very concerning about the Irish system, as we're now told it is, because we can't trust them anymore, they're not trustworthy, and I've proven that. The most, I suppose, disconcerting thing to the citizen who's concerned about these things is that somebody can write something and they present the bill to the president. This is what we want to do, this is how we want to change the legislation or amend it or augment it or add to it, whatever. And he'll say, right, well, I'll sign that in or I won't sign that in. But what are the bases upon which the president would refuse a bill? And what are the bases upon which the president would sign something in? So what is it that's helping him make his decision? Why would he say yay or why would he say nay? Isn't that a going concern? And how is that democracy? That's a democracy, basically a pretendy democracy, because you're saying that one man is giving the authority, in the absence of any democratic processes, of signing something into legislation. Where's the democracy? So these people have corrupted the Irish country. They've corrupted the systems, and there's a very rude saying that I won't repeat, but I will say they're breathing down your neck and telling you it's very windy. They are pulling the wool over your eyes, telling you have a democracy, when they've pretending to give the president the power to sign something in or not, without going through any democratic processes. That's a dictatorship. That's essentially a dictatorship. We don't live in a dictatorship. But also, what's concerning about that is, at that stage, if the president refuses to sign something in, the Supreme Court can at that stage be, what's the word I'm looking for, consulted on the matter, on the bill that they want to pass or write into legislation or into the law. Well, why don't they do that every time? If the Supreme Court are the ones endowed with the adequate knowledge as to whether something is constitutional or not, why aren't they always consulted? So a president who's not a barrister, who's not versed in the law to the extent and degree that somebody who's an expert on the Constitution or on the law would be, is given the sole responsibility of signing something in or not, when he's actually not the best qualified person to do so, to make that decision. So why is it only sometimes that the Supreme Court would be consulted, and why isn't that a going concern? But in any case, that's a dictatorship, because you haven't consulted the people. Furthermore, what's interesting about the Irish system is, even after the president has signed something, whether it's wrongful or rightful, Because they're saying that the president can sign something into law that isn't necessarily constitutional. They're saying that the president can sign something into law that has to be presumed constitutional. Excuse me? So you're saying something can be signed into the law by a president who could be corrupt and have an agenda other than the best interests of the Irish people, and we have to bow down to him as though he's God? Unless at that stage it's questioned by him or he seeks the consultation of the Supreme Court. Sort of seeking certiorari, seeking a better qualified person on the matter. A higher dispensation of authority. Because what's interesting is this is a democracy, it's not a dictatorship. The president has limited power. But they've given him sole responsibility for the most important duty, which is deciding what goes into the law. That's ridiculous. Because you only need one corrupt person in the president's seat, and now you can write whatever you want and call it constitutional. And what's more ignorant and redundant and retarded of the system is that they will say that we must presume thereafter that it's constitutional, even if we have knowledge that it isn't, as citizens. So now we can have a corrupt president corruptly signing things into the legislature as though they are law. He might know they're not. He might be corrupt, and he might sign them into the law, and we have to presume that they're lawful. Okay, so the plot thickens, because any citizen is allowed to bring a test of the constitutionality of any section. Did you know that? Any citizen in Ireland is allowed to, entitled to, by law, bring a test to the constitutionality of any section within the law. It's your right, and actually your obligation if you find that something is in the Constitution and it's unlawful. You would say that that's the reasonable obligation of a person who's better informed than the general public on these issues, who discovers that something is unconstitutional. He should be duty bound also, then obligated also to bring it before the High Court. And what's interesting is a citizen brings it to the High Court, but the President brings it to the Supreme Court. Now both are high-ranking courts. They're both considered superior courts. You would seek certiorari from them. You would seek their higher knowledge on a specific topic. But having said that, you can also have corrupt barristers who mightn't interpret the law correctly. But then, there are many people in there who might say, hold on a second, I don't think that'll wash. So the only thing that tends to restrain them in their corruption is exposing their corruption before the peoples and before God. Because they'd happily do it from here till ever after. They're just crooked. So when you look at the amendments they've made that no longer even value the life of the baby in the womb, why would you think that they would suddenly draw the line there and stop corrupting the system? No, this is barbaric behaviour. So they're clearly willing to be barbarians, and this should concern you, that they now have sole responsibility on what's signed into law or not, unless a test of the constitutionality is sought. And you're entitled to do that. You can go now to the High Court and you can apply to test the constitutionality of any section if it pertains to you, or if you have an interest in it. Well, I would say that any section of the Constitution should be interesting to the public, don't you? Being that it addresses our daily lives. How can you say that something that pertains to why you might be arrested or not doesn't affect you as a citizen? But they say you have to show that you have an interest in it, that you're interested in the result, that you have something to do with it. It's preposterous to suggest that a citizen who's bringing a test to the constitutionality of a section doesn't have something to do with it. They're a citizen. Of course they have something to do with it. So the point is that I brought a test to the constitutionality of sections 115 and 117 of the Criminal Justice Act 2006. I have an interest in those things. I was arrested and imprisoned for a month on foot of that section, and others similar, related, and adjoined, and they are 113 and 114 of the same Act, and Section 7 of the Criminal Justice Public Order Act 1994, which has the word insulting in it, which has been removed from other jurisdictions, but Ireland tend to be aggressively non-committal and very slow to act. So it's not because they're stupid, it's because they know why they're failing to do something. It's not because they're ignorant of it. They know exactly why they're not doing something. So with regards to the test that I brought before the High Court, it was number one on the schedule. They actually scheduled it. The court case commenced. Can you imagine that? Right, court in session. Boom. Okay, what's number one on the schedule? Test the constitutionality of 115 and 117. Judge. And this was all during COVID now, so it was all done remotely, and I wasn't even present. Interesting, isn't it? So I'm not there, and what did I do? Abandon the test of the constitutionality of that section. Why? They told me they didn't even need me there. I wonder why. Don't you? They're going to fail to do what is fundamentally the most important task they had, test the constitutionality of sections that have been called into question before the High Court. They said they would do it, no problem, we should do it. They started doing it, scheduled it, begun the case, and abandoned it midway. Told nobody. I was notified after the court case result was posted on courts.ie. So it was actually available to the general public before I was told, and I was named in the case. So I bring the test to the constitutionality of that section. They tell me, yeah, we'll test that, no problem. Then they start the test, abandon it mid-case, and don't tell me. Then I read the conclusion of the judge. He said, it remains an open question as to whether Section 115 and 117 of the Criminal Justice Act 2006 are constitutional or not. How does it remain an open question, does it? Well, why didn't you test it? And this should be done in an appropriate case. Well, why is this one inappropriate? You started it. So they didn't say it's inappropriate at any stage. They alluded that there would be an appropriate case. They didn't say this one wasn't appropriate. So all they did was abandon the test. That's highly suspicious. Because the fact that they started the test and then abandoned it says that they know, they've done their homework on it. They don't just start looking at the section when they start the court case. Because the judge has to know what he's bringing before his court. So when they start, after they hit the gavel, court in session, they're now lawfully obligated to complete the task set before the court. They're now lawfully obligated to complete the testing of the constitutionality of those sections. And the fact that they didn't implicates them in a conspiratorial failure to do so. Because there's more than one party involved in that decision, so it must have been conspiratorial. But what's interesting is there was a barrister in the court, my representation, because I was on legal aid, and the barrister was in agreement with me. Now, I wouldn't have hired him if he wasn't, or if I thought he wasn't. But later on, it showed that they didn't have my interests, so I had to sack them. Because they didn't even tell me what happened in the court. They didn't even tell me the court had abandoned the testing of the constitutionality of that section. So there's a conspiracy for you. So it looks like my barrister was in on it. Doesn't it? It does look like that. Because they abandoned the test of the constitutionality of the section, and my barrister doesn't even tell me. That's highly suspicious activity. Anybody, like, I mean, policing 101, and, you know, and Inspector, what is it, Cluedo or Crudo, what's it, Crusoe? Whatever his name was, I can't think of it now. I mean, you don't have to be as wily or as clever as him to see that that's basic. Your barrister's there to ensure the test is carried out. And when the court says we're not going to do it, but we're rather going to abandon it, your barrister doesn't even tell you. That's a rotten conspiracy. That's what that is. Because he conspired not to tell me. Because he's duty bound to tell me. He's paid to tell me. So should I pay him if he doesn't tell me? Should we pay the court if they don't do the job they were assigned to do, brought together to complete? If somebody pays me to paint the wall and I take the money and don't paint the wall, what happens? You'd seek legal action. Say, that man robbed me. If it's found out, like, you know, it wasn't something out of his control. But it wasn't out of the court's control. They decided we're not going to complete this task, and they didn't tell anybody why, who was named in the case. They didn't tell me. I'm sure they told the state, because it was in the state's interest. But they didn't tell me. Why do you think they didn't tell me? Because they must have found something in those sections that they didn't want to remove, or they were trying to save face because they thought, we can't win this. So they were trying to save face and back out of the test and hope that I would just go away on foot of them quashing the convictions. But when I didn't go away on foot of quashing the convictions, what I did was I started talking about, where's my compensation? If you're quashing the convictions, where's my compensation? You've put me in prison for a month. You told me I couldn't speak for 2 years on account of a civil order that was quashed and called unlawful. I was under threat of and duress of arrest for years, 2-3 years. And what happens? No compensation. They didn't even mention compensation after they quashed the convictions, let alone motion to compensate me. Because it's absolutely incumbent upon the court, when they find that you've been harmed in some way by, you know, a member of An Garda Síochána making a mistake, or a judge doing something wrong, when judicial review or reviewing how the judge went about the day in court is carried out, and they find the judge didn't do something right, but that you spent time in prison, or that in some way your rights were reduced, or there was an order taken out against you and it shouldn't have been, or there's some kind of loss to you. Excuse me, whether it's the trauma that would ensue, and as a result of being told if you talk you're going to be arrested, like, or whatever it was, just the inconvenience and the cost to you for not having been allowed to embark upon your rights without guards coming around and telling you you'll be arrested if you do, and put in prison, and then actually being arrested when you do, and spending a month in prison, even though that civil order was found later to be unlawful. Then there's a responsibility on the state to compensate you. It's actually written into the Constitution that if you're harmed in any way by malpractice, by the improper implementation of the law, by wrongful arrest, by wrongful imprisonment, any of the above, and more besides, that you should be compensated for that. That your right to a good name be restored, that your name be restored, that your rights be vindicated, that your name be vindicated, etc., etc., etc. That should all ensue as a result of having your convictions quashed. They told me that civil order that you were under threat of duress of arrest under, that wasn't even lawful. should have never should never happened. But yet, knowing this, they didn't complete the test of the constitutionality of the section that brought about that civil order, even though they were asked to. So now they have evidence that people who are using, or people, members of state, guards, etc., who are using these legislations to arrest people and imprison them, are wrongfully imprisoning people, wrongfully arresting them, wrongfully putting civil orders in place as a result of these sections, yet they claim that it still remains an open question as to whether they're constitutional or not, and didn't complete the task of testing them, even though they have knowledge that people are misusing them in the aforementioned ways. How is that competent? That's conspiratorial treason, is what that is. Because now they have knowledge that those sections are unconstitutional and they're being used in an unconstitutional way to harm people's lives. They're not compensating the people who are harmed, and they're not completing the test of the constitutionality of those sections. So they're failing to test the constitutionality of those sections, willfully knowing that the High Court have recently said members of An Garda Síochána are not allowed to prosecute in court. But those sections that they said that they test the constitutionality of, or were mandated to test the constitutionality of by beginning the test of the constitutionality of, they failed to complete. And so these sections tell guards that they can prosecute in court, when the High Court says that they absolutely can't. So now there's that conflict that they're now aware of. I mean, the High Court are aware of this, because the High Court is the High Court. I mean, it wouldn't be logical to expect that one judge of the High Court would have different knowledge on the law or of the law than another judge in the High Court. They have to have the same knowledge. So if one judge rules guards can't prosecute in court, and another judge knows that there's a section of the constitutionality of the legislation that is basically telling guards they can prosecute in court when the High Court says they can't, then it's the responsibility of the one who rules that and knows that and is aware of that to remove the sections and go about having them removed. So it's not good enough for members of the bar, members of the judiciary, solicitors, lawyers, guards, etc., to have knowledge that something in legislature is unconstitutional by way of even a recent High Court ruling, and previous besides. I mean, all the High Court really did was reaffirm what we already knew, and that guards can't prosecute in court and they can't represent the evidence of other members in court either. So all they were really doing was reaffirming that. We knew that already, but most certainly the sections of the Criminal Justice Act 2006 were therefore and thereby totally found to be unconstitutional, because they say that a member of superintendent or higher can prosecute in court, or a member of superintendent or higher can represent the evidence of other guards, possibly 3 or more separate individuals or separate members of An Garda Síochána, which is ridiculous. Because that's like having a guard there standing in court in a civil jurisdiction where he shouldn't be, because guards have no jurisdiction in civil matters, basically playing lawyer to whoever he chooses, and while representing the evidence of 3 or 4 members of An Garda Síochána, who this legislation claims or states don't even have to be present. So they don't even have to be present to ensure that the information that's now been read out as their evidence is sure. No, that's not the case. That goes against the law. So the judge on the day couldn't establish jurisdiction, because in order for a judge to say, right, court in session, or court open, court commenced, court in progress, whatever way he terms it, in order for him to start the day in court, in the case in court, he has to know that all his ducks are in a row. You can't have guards doing things they can't be doing. You can't have lawyers doing things they can't be doing. You can't have the court clerk doing things they can't be doing. So the judge is there to ensure that the administrative procedures of the court and every other procedure of the court is done properly. And he can get quite sort of stern at times when things get out of hand, because he has to keep it in order. And so, because these are very important and integral processes in law and order and the proper functioning of society, and people knowing their rights and being afforded their rights, and respecting the rights of others, and all such things, knowing your rights and your responsibilities, etc. So it's so integral that a judge can't establish jurisdiction if he sees members who are engaging in that court session who shouldn't be there because they don't have jurisdiction, or are behaving in a way that they're not authorised by their office to behave. So for whatever reason something's not right in the court that day, the judge hasn't established jurisdiction, which means he can't actually lawfully make a ruling because he doesn't have the authority or the warrant of the court. So if a judge doesn't have warrant of the court, he can't ratify that what's going on in the court is lawful. Therefore it's unlawful, because they're not allowed to use the courts to entertain themselves. They're there to do court cases where they've established jurisdiction under the warrant and conditions of court, and that they can ratify as constitutional. So if you have judges accepting testimony from guards as prosecutor, they don't establish jurisdiction, and now they're conspiring against the Irish people, the Irish government, the Irish courts, and the whole constitution, because it's so fundamental. It's so basic, it's so systemic. It's at the core of how the country operates, how the courts operate. So now we know that there are errors in the legislature that are very serious. Like, they're huge. This is not small, it's huge. Telling a guard he can play prosecutor in court? No, he can't. Not only that, telling a guard he can play prosecutor in civil court. Well, he's not even allowed past the door of the civil court as a member of guard giving testimony, or a member of a guard Síochána giving the testimony. He's not allowed to do that. The only thing a guard is allowed to do in court is give evidence. That's it. He's not required to do anything else. He says, I saw this man named driving his car 20 miles over the speed limit. 20 miles per hour over the speed limit. Excuse me. Day, time. You sure it was the person in question? Yes, I approached the vehicle and I can confirm that it was this man. He gave me his driving licence, and he might say of how they conversed or whatever. And that's it. He's only allowed to give evidence, his own testimony, or produce solid articles as evidence. That's it. He's not allowed to do anything else. He's not allowed to prosecute. He's not allowed to play lawyer, attorney, solicitor, nothing. Just give evidence, and that's only in a criminal court, a criminal jurisdiction. He doesn't have any jurisdiction in civil matters, none whatsoever. He doesn't. Ask him. He'll tell you. I asked a guard on his beat outside the GPO in Dublin. This is a good while ago. And he said, or I asked him rather, do guards have jurisdiction in civil matters? He did this. No, absolutely not. So what these sections are trying to drag people, members of Garda Síochána, into the civil court and to get involved in matters prior to that they don't have any jurisdiction in. The adult behaviour warning system tries to drag guards into civil matters so that the people they want to shut up feel that there's a degree of apprehension that they might get into trouble if they don't do what the guard says while he's out of jurisdiction. It's bully tactic, it's terrorism. Guards don't have jurisdiction in civil matters, period. They don't. And sections that say they do must be removed for those members or those parties involved to avoid felony. The constitutionality of those sections the High Court began to test and abandoned. They're now conspiring to fail to do their duties. They're now conspiring to commit treason. The High Court have said that these people, members of Garda Síochána, can not prosecute in court, any court. They cannot represent the evidence of other members, ever. Only their own evidence. The sections I've mentioned tell them that they can. And that's treason. And it's not, oops, we didn't know, oh, oops. Because now for years, it's been before the High Court. And they still haven't removed those sections. That's conspiracy to treason. So I would say anybody who's involved in that, any judge, any guard, any legislator, remove that quick. Or you face treason charges. This is very, very serious. It's different if, well, we didn't even know. No. You commenced testing the constitutionality of those sections. You started the test. You had somebody before you, somebody named before you, who had been wrongfully arrested and imprisoned as a result of those sections. So I think that's an interest in the test. So you had a justifiably interested party in that matter bringing the testing before the High Court, and you failed to complete the test and you didn't give any reason. That's not acceptable conduct of the High Court. Now they're uttering nonsense like, you must presume it's constitutional until it's proven otherwise. What's the hold-up? The High Court have proven it unconstitutional. Because there are members of Garda Síochána being told they can prosecute in court when they can't. That makes it unconstitutional and means it should be removed with immediate effect. So now you have judges, legislators, guards, members of the High Court, members of the Court of Appeal, fully aware that the constitutionality of those sections is highly questionable, and the High Court have ruled against some of the functions that they're being told they can engage in those sections, and they haven't removed them. That's conspiracy to treason. So do you want to hear my gavel? Removed. In Jesus' name. Because now they run the risk of treason. So let them be removed. There used to be a penalty, and I don't advocate for physical violence, but just to stress the importance and the seriousness of treason, the importance of policing it. It used to be in 1983, I think it was, the year I was born, the case that you would be killed for treason. You, as a judge, if you commit treason, you would be killed, dead, for treason. Only in 1983 did they remove the penalty for treason. And again, I don't advocate for death penalty. But that'll just show you how seriously the state looked upon the act of treason. That they would kill a man for it. Now you're talking about 20 years in prison for it. And there's a handful of them running the risk of it. They're committing treason. They know there's a section of the Constitution, I'm talking about it long enough. They know there's a section of the legislature that's not constitutional. The High Court have ruled on those parts indirectly, because remember, they abandoned the test for no reason. Then they said no, guards aren't allowed to prosecute in court. They're trying to tidy up the mess without you knowing they made a mess. But until they remove the sections, they haven't tidied it up. And they continue even more so, because now they know that the parts of those sections are unlawful by way of a High Court ruling, which I can prove. I can prove that court case. The judge found, it was a female judge of the High Court, she found that guards can't prosecute in court. Those sections say they can. She found that guards can't represent each other's evidence in court. Those sections say they can. We already know they can't have any involvement in civil matters. Those sections say they do. So those sections have to be removed. What's the hold-up? The hold-up is a conspiratorial treason. And they'd want to really get up off their hands and get it removed as quickly as possible. In Jesus' name. So I'm pleading to my fellow man here, my fellow Irishman, my fellow citizen, and fellow human. There's conspiratorial treason taking place in Ireland. Because they're not in ignorance, it's not up for question. We know that those sections are unconstitutional. So that means that those sections have to be removed. And those who are duty bound to carry out that test and were assigned to carry out that test are now part of that conspiracy. That's how serious this is. They're sitting up there and they're failing to do what they know they're duty bound to do, and it's highly, highly suspicious activity. Yeah, we'll test the constitutionality of those sections. We didn't test the constitutionality of those sections. Why? It remains an open question as to whether they're constitutional or not. Then the Court of Appeal says we must presume they're constitutional. Why didn't you finish the test and remove ambiguity? We're talking about the constitutionality of a very integral section of the legislature which pertains to how guards behave in court. This is very serious and is of grave import to the public, and you haven't even kept them in the loop. And you haven't even kept the named party who was named in the court case in the loop. It's conspiratorial treason. The High Court have said guards can't prosecute. Those sections say they can. Remove them. In Jesus' name, amen. Blessings.